en por lo menos 30 tratados, ¿no? Algún caso de obligaciones de los inversionistas. Y son contados con los dedos de una mano. Y de, digamos, obligatoriedad suave, porque no son judiciables en la mayoría de los casos. Ni siquiera el caso de la consulta previa de las comunidades afectadas por una inversión, ¿no?, puede ser llevada a tribunales internacionales. Entonces es muy desequilibrado el que los tratados pretenden proteger derechos de los inversionistas y no tenemos dónde proteger los derechos de las comunidades y de los pueblos. Entonces la pregunta es que me den ejemplos, si quieren, no de los que ya están negociando, porque dicen que es secreto de Estado, sino de los ya negociados, en el que nosotros podamos defender nuestros derechos.
Thank you. We'll take one more question right there, and then.
Yes, my name is Pierre Serineta from the Quebec Network on Hemispheric Integration from Quebec, Canada. A first element of lack of transparency is also in what language the texts are being negotiated. So I'll switch not to French, but to Spanish, a middle term process, because I understand the Canada EU is being negotiated in English solely. Entonces, mi primer punto es, primero sabemos con un documento filtrado que el mandato, en el caso de Canadá y Unión Europea, el mandato para la Unión Europea es el mecanismo de disputa inversionista-Estado. Ya lo sabemos, ya no es Estado-Estado, sino inversionista-Estado. La pregunta que yo me hago, y espero que ustedes están conscientes de eso, es que el mecanismo inversionista-Estado, para nosotros que tenemos experiencia en el NAFTA, es que tiene un impacto importante precisamente sobre lo que ustedes dicen que van a proteger, el espacio de política y la capacidad de reglamentar y regular. El mecanismo inversionista-Estado restringe esa capacidad de regular y de mantener un espacio de política autónoma, lo que llamamos el efecto resfriante, chilling effect en buen francés. Entonces es importante tener eso en cuenta, porque además eso da más poder a las empresas en sus esfuerzos de cabildeo. O sea que no necesariamente necesita utilizar el mecanismo hacia una disputa y una queja, sino que lo utiliza, el gobierno ya empieza a estar temeroso. Primer punto. Segundo punto, una pregunta para ustedes. ¿Por qué la Unión Europea ha cedido sobre la negociación en ese campo lista negativa? ¿Por qué? Y la pregunta que es relacionada, la Unión Europea sí ha pensado cuál es la relación entre el NAFTA y el acuerdo ya existente desde el 94 y el acuerdo entre Canadá y Estados Unidos, y si están ustedes en esa perspectiva de lista negativa, es decir, todo lo que no se excluye está excluido. ¿Están ustedes negociando, identificando qué está excluido en el NAFTA y qué es lo que están tratando de excluir entre Unión Europea? Y finalmente, para despejar una duda, por si ustedes tienen duda, pero en el caso de Canadá, las provincias están negociando y Quebec en particular fue invitado a la mesa de negociación. Pues les puedo decir que Quebec tiene sus mecanismos propios para ratificar el tratado. Y vamos a impulsar esos procesos para que precisamente se ratifique, se debate públicamente, texto en mano, ¿sí?, antes de ratificación, el tratado. Ahora, les puedo comentar, por si hay duda, que también en Canadá hay un mecanismo que llamemos el mecanismo derogatorio, es decir, una provincia se puede sustraer de una política federal, o sea, canadiense, Y puede ser el caso que si algo no nos gusta en Quebec, nos vamos a sustraer de un compromiso que Canadá ya ha podido tener con la Unión Europea en materia de libre comercio, si consideramos en Quebec que nos limita la capacidad de regular y de reglamentar. Gracias.
All right, I guess EPAs and CETA should probably be for Leopoldo, and maybe Pascal will have a crack at obligations for investors and anything else you want to say. If you could keep it as concise as possible.
Muchas gracias. Me gustaría contestar en español, pero mi español no es bueno bastante. Entonces reverto a inglés. Now, on the EPAs, that is a complicated story, and I don't want to go too much in details. 2 points. Why have we engaged in EPAs? For several reasons. One, because we wanted with the EPA partners to work out the possibility through international agreements to reconcile trade liberalizations and development concerns. This is at the heart of the whole of the development angle of the EU common commercial policy. True, an international agreement creates obligations, yes. Otherwise, we wouldn't have an international obligation. We wouldn't have an international agreement. But as I said, we still take the view that through a certain number of carefully drafted language, we do ensure a sufficient freedom to regulate. Of course, not to do anything, but a sufficient freedom to regulate in the public interest through legitimate regulations which are applied in a non-discriminatory manner. The problem with the EPAs is that we cannot, under the WTO rules, we cannot go on indefinitely in granting only a certain number of countries trade preferences, because we are bound by the obligations in the WTO to apply the trade preferences in a non-discriminatory manner when we do this through autonomous acts. We can have a derogation from the WTO if we do that within the framework of international trade agreements. So there is an issue there. But as I said, my clear take on the EPAs is that they do allow for a sufficient policy space. On Canada, the negotiations are being conducted in English. When the negotiations are concluded in the European Union, they are translated into all the official languages of the European Union, and all the European languages become original languages of the agreement.
Including Spanish.
Including in Spanish and in French. I don't know what happens in Canada. On the ratification of an international agreement in the EU is subject to a council decision, first of all, and then the entry into force, depending on the contents of the agreement, is subject to national ratification by all the 27 member states. But the modalities for the ratification depend on the contents of the agreement, so it is too early now to say exactly what is going to happen. On why have we accepted negative list? Because Canada considered that this was very important for them to engage in the negotiations, and because we thought that by agreeing to negative list, we considered that by agreeing to negative list, we would have an even more ambitious agreement, which is what we wanted. A negative list still allows for 2 elements to be protected. One, legislation that continues to constitute a lack of market access or a lack of or a discrimination, and 2, a list of measures whereby the respective partners allow themselves the necessary policy space. The negative list with Canada is the first time we do that, and Pascal is well placed to say how difficult it is, and it has been for member states to come with lists. We have now exchanged a first draft list with Canada, with the understanding that we would be able to come back to those lists while we continue to find out what the necessary limitations should be in the member states. And I know that the member states continue to work on that. I will not comment on Quebec's right to withdraw from the agreement. This is Quebec's and Canada's internal policies. On investor to state, I mean, again, I come back to what I was saying. Of course, I know that there is a view which says that investor to state restrict the policy space, that there have been awards in the past which have created, which have condemned legislation passed by member states. We don't fully agree. We agree, of course, that when you give this kind of rights to investors, you have a risk. It's clear. I mean, we should not hide that. We think that in the case of the European Union, the risk is remote on the basis of notably what Pascal has said, that so far we don't have a real history of member states being condemned. The chilling effect of legislation just because of the existence of investor-to-state dispute settlement provisions, in our opinion, is not established. But we come back to what we think is that we do think, and we certainly do intend at European level, to have language in the agreements which allows the countries to have the necessary policy space. Of course, as Marc said, and I think he's right, he said, well, I want to see how this is going to be reflected in the treaty, so do I, and this is something that we have to still negotiate, but certainly the objective is there. I will stop here.
But member states will call that a step back.
No, now, just to come back, can I come back to what Marc said?
Yes.
Just very briefly, Marc, first of all, in relation to the renegotiation of BITs, I haven't said that the member states see this as a step back. I said that the third countries with which they negotiate take a negotiating stance which says, if you want now to introduce limitations to capital movements, this is a step back. This is a stance the negotiating partners are taking, not the stance that the member states are taking. I don't agree with you when you say that anything, even a comma or a iota, that changes the practice of member states will be considered a step back. I think we have to see the substance and the merits of the various legislative proposals. But the objective remains, is that even though member states have different BITs, there is no one European standard, the expectation is there. The expectation is there is that we bring added value at European level, and that this added value must include, it is not the only thing, but must include a guarantee for the European investors that they will not be treated worse off in an EU-level agreement compared to a member state agreement.
Pascal, briefly. By the way, I think we can maybe stay a bit longer. Are you able to stay 20, 30 minutes longer? Is that okay with you? Mm-hmm. Good, excellent. So we'll have more time for questions. Go ahead.
First of all, to react to what Marc said, and in addition to what Leopold said, is that we cannot blame the member states to defend their own interests. I mean, in negotiations, if they have to comply with the EU law and they have to approach the third party and to say, listen, we have a problem with our BIT, we have to change this small sentence, we suggest that we change this sentence and we add this. Do you agree? They can say yes or no. I mean, this is not the role of the member state to say, look, we want this, but we will defend your interest, and so it could be good for you to take this sentence aboard. Because don't underestimate the negotiation power of the third parties. I mean, it's quite difficult, and we see that for with some third parties, and they want to reopen the old agreement sometimes, just on the basis of the small clause on transfer, which is sometimes problematic regarding the EU law. I don't agree also with the idea of saying that the transparency is a setback. It's just the idea, the member states are quite logical. They want something efficient, and sometimes to be efficient is keeping some information confidential. This is the same for the negotiation directive If you want to be efficient, you have some time to maintain a certain level of confidentiality. It's logical because they're third party. They are not transparent. We don't know what they want, what are their red lines and so on, what are their priorities. So to negotiate an agreement, it takes years just because of that, because we have step by step to say, well, this is maybe a door which is opening on this sector, for instance, which is interesting for us. But we don't know that in advance. So why should we give our priorities or main interest immediately to the third party, and the third party doesn't do the same to us? I mean, don't underestimate the negotiation power of the third parties, and for instance, I think about India. Regarding the question of transparency in the third country, like in Mexico, this is sorry, sir, but it's a question and it's an issue for the Mexican authorities and the civil society there. I mean, if the EU comes to the negotiating table and to say, listen, you have to do this internally, I imagine the criticisms that the EU will get. So they are free to organize themselves all they want in order to negotiate with us, and they are not obliged to negotiate. They have an interest to come to the table too, but the way they organize themselves is their freedom. And you can see that also with Colombia, for instance. The civil society participated in the negotiation process internally there in order, to deal with this human rights issue. So it happens. But it depends mainly on the third parties. Regarding the CETA negotiations with Canada, once again, the internal way, for organizing the negotiation, but on the Canadian side, it's something internal. I mean, the EU has nothing to do with it and has no right to say anything regarding that. And negative list, this is a request of Canada. And as Leopold said, it's true that for the member states, negative list approach is something quite unusual and quite difficult. During months, we have worked on that with all level of power, for instance, here in Belgium. I mean, it means from the commune to the federal state, and to see what is the legislation. And it's not an easy process, but as Leopoldo said, we think that it could give consistency to the idea of concluding a comprehensive economic and trade agreement, this CETA. So this is a way to do it. Canada wants it, why not? But it takes time because we want to defend our interests too, as Canada and the third parties does.
Thank you. All right, right here. In fact, yes, go ahead.
My name is Natalie Bernasconi from the International in Geneva. You can't hear it? My name is Natalie Bernasconi from the International Institute for Sustainable Development in Geneva. I just have two short comments and a question of clarification. The first question or the first comment relates to what has been discussed quite a bit about not being able to go back on the level of protection. And there have been some studies on this as well. If you look at the member state investment treaties, the language is extremely vague, extremely broad. So that means that the level of protection can be maximum for the investor, but it can also mean that it can be maximum for the state. And what will it depend on? It will depend on entirely who constitutes the tribunal. Three people chosen maybe from a club kind of system, and there is no appeal like in the WTO. The decision is final and it can be enforced. So there's something inherently wrong about this idea to talk about the level of protection that the investors have now, and that they will have a different level, or it will be reduced if you do this and that. It's just about whether you clarify the obligations or not. And this clarification process has taken place in North America, in Canada and the United States, because the countries were sued. Canada has been sued 30 times. And I would say the only reason that they're even contemplating doing this again, signing another one, besides some of the economic interests, but the defensive interest, is because they're trying to have language that gives them this predictability. Right now, member state BITs are not predictable. And you put the outcome in the hands of 3 people in a system that is not managed well, like maybe the WTO appellate body or so on. So that's just one comment. The second comment about UNCITRAL. It's nice to say, oh, UNCITRAL will take care of the issue of transparency in investor-state dispute settlement. But it won't. And a big part why not is because the European member states have been incredibly negative towards even attempting to discuss the issue of transparency. The Commission has taken a different stance. I don't know, there are some internal issues there, and maybe member states are coming on board, but don't count on that process. It won't apply to existing BITs, this transparency rule, and perhaps not even automatically to prospective future treaties. So the only way that you can get transparency into the treaties is by putting it into the treaties. And the United States has done that, Canada has done that. Then just a question of clarification. So is it correct that there will be a cutoff date by which the existing investment treaties will be grandfathered? And is that cutoff date, does it relate to treaties that have entered into force? Must they have entered into force by that date? Or is it, do they just have to have been negotiated? Second question of clarification, for the restrictive conditions, it was already mentioned, this issue of transfer clauses. Can the Commission, who actually initiated the discussion at the European Court of Justice, can they now grandfather a treaty that has a provision that has been clearly said to be in violation of EU law? Thank you.
Okay, so thank you. Okay, does that work? Oh yeah, okay. So my name is Gus Van Harten. I'm a legal academic from Canada, from York University, Osgoode Hall Law School. And I've been observing international investment arbitration for a number of years. I'd like to thank you for the presentations. I learned a lot, and I'm very grateful for you taking the time. If I were to highlight one point, we didn't coordinate this, but it's along the lines of what Natalie was speaking about, which is, I think it's widely recognized there's a need to formalize, institutionalize, regulate the arbitration process to make it, not to necessarily replace investor-state arbitration if that's just not in the cards, but to make it a more reliably independent and fair and open process, moving towards a court-based model. And we have examples of other arbitration processes that do follow that model. And for example, Canada has an agreement on internal trade that has an individual to government arbitration mechanism that incorporates a range of safeguards of independence that they're really needed. So it has a roster, it has a binding code of conduct built into the treaty. It has objective methods of case assignment. It has a screening mechanism to root out frivolous claims. And, I think it's fair that many observers would say that the NAFTA governments were very troubled by some of the ways in which arbitrators took the treaty in some of the awards, not all. So, for example, in the GAMI case, the United States, which was the investor's home state, and Mexico both submitted that the meaning of a minimum shareholder interest should be interpreted in a particular way, and the arbitrators rejected those joint submissions of the affected NAFTA governments about how their treaty should be interpreted in favor of the investors, much more expansive view. And likewise in other cases, Pope and Talbot on non-discrimination, all 3 NAFTA states submitted one view as to a particular interpretation, and the arbitrators rejected that. So that leads to my question, which is from the European point of view, is that still possible? Is it still open that the treaty could adopt some more formalized approach to investor-state arbitration involving the kinds of mechanisms I've been referring to? I would very much welcome your thoughts on that.
I think we'll go straight to answers on that. Excellent questions. Go ahead, if you can talk about that.
Thank you. Thanks very much for these questions and comments. I think you're touching both on very important issues. As I said in my introduction, whereas we think we have now more or less mapped out in broad terms what is it that we should achieve in terms of the substantive standards, but I'll come back to the comment of Ms. Bernasconi, there is still some way to go in terms of arbitration. We think that we have agreement with institutions that we should have in our agreements, of course, the state-to-state dispute settlement as we've had in our FTAs so far, but with regard to investment protection, we should also have a system of investor-to-state. The details of that are not decided yet. They're not decided internally, and they're not decided with our negotiating partners. As Marc said in his introduction, in the communication of July 2010, the Commission has indicated a certain number of elements that it considers are challenges. The Commission has not indicated the solutions, but has highlighted the challenges. 1, transparency. 2, the atomization of disputes and interpretations, where consistency and predictability are key issues. And we float the possibility of considering quasi-permanent arbitrators. And then the question of the rules of conduct of arbitration. So we have flagged those challenges. Now we have to see, first with the member states, what is possible, and then with the negotiating partners, what is possible and desirable. But I fully agree that there is an issue there that we need to reflect on. So is it possible, is the question still open to answer the question of the gentleman? Yeah, I think so. Will we come with definite solutions immediately? I don't think so. Will we have to have a progressive system whereby we improve on the situation? I think this is the most likely situation. You know, in relation with Canada, I often hear some people saying, oof, it's going to be very complicated and dangerous to negotiate with Canada because the NAFTA leads to certain cases to a lower level of protection than what the member states' BITs have. I also do think, however, that in relation to arbitration, Canada can bring very valuable experience. And I look forward to the negotiations with Canada in this specific case. Now, staying in the theme of arbitration, I take the point of Ms. Bernasconi when she says that the standards are not so clear and you know, there is a need to develop them. I think that in terms of the conclusion of an agreement, it is at the end of the day the point of view of the Council and the point of view of the Parliament that will prevail after the Commission has considered that it can safely conclude the negotiation, to determine whether indeed what is achieved is sufficient to be concluded. And that is going to be a call for the member states. And each member state will come with its own experience. And since they don't have identical BITs, they will all have to make a judgment on the result of the negotiation. On UNCITRAL, I haven't said that the work of UNCITRAL will be a solution to all evils. I've just given UNCITRAL as an example of a discussion which is taking place internationally about transparency. This, of course, is not the only discussion that should take place. Now, coming back to your question on grandfathering. The basic idea of the regulation as the Commission has proposed it is the following. Agreements which are in force by the date of entry into force of the regulation can be notified by Member States to the Commission. When these agreements are notified, they are grandfathered. There is currently a debate between the Commission, the Parliament, and the Council as to whether there should be any review by the Commission of the contents of these agreements grandfathered. And for the time being, I think it is safe to say that there is no decision. This is still open for discussion. What about agreements which would be in course of negotiation when the regulation enters into force? This would be covered by the second part of the regulation, or Chapter 3 of the regulation. In other words, for the conclusion of these agreements, the Member States would have to ask the Commission. And the Commission would have to decide whether or not the Member State can conclude these negotiations on the basis of a certain number of criteria which are included in the regulation, which include the consistency of the provisions of the BIT with the overall EU investment policy, and let's see whether this stays in the final text of the regulation as adopted. Thank you.
Did you want to add something?
Yes. First of all, thank you for your intervention. I think it's quite, it was very interesting, and I agree with you. It's sometimes, you know, the devil lies in the details, and the issue of the arbitrators, it's a very important one. But as Leopoldo said, the negotiation directives have been adopted and given to the Commission, but we haven't finished yet the whole process of discussing with between the Member States and the Commission in order to define exactly the content of an investment protection chapter in the agreement. This is something, you know, we still have to do. And in our minds, we want, you know, Canada is one of the first countries that we will negotiate with, and this is the idea, to see what their experience is in Canada. And not only there, because we are also in contact with the US, because the US has launched a process of reviewing their own BIT model. So it's we would like to see to know why and what are the difficulties. And it's true that the language we have globally in our BITs is quite vague, but it's because it's quite difficult. We don't want to exclude particular situations and afterwards to say, well, we should have thought about it. And at the same time, it's even more difficult because, and I can assure you that the Member States want to protect their own right, and not only the right of the Member States, but also of the EU, of course, to regulate. Be sure that the Member States will defend these very important principles for themselves, but if they do that for themselves, of course, it's a two-way street and agreement. It's also for the third party. The clauses are valid for both parties. And so we are in the process of creating, you know, this new policy and the system. It's true that we are discussing about, you know, a list of permanent arbitrators, for instance, but which one and so on, we don't know. And how are we going to select them? We don't know either. And so we still have to think about it. Regarding the cutoff date, this is what the Member States are looking for is a pragmatic solution, and it's something you know we have repeatedly said to the Parliament, for instance, in our contacts, because they will have to decide it with us, and to be sure that they understand our concern. no matter the way we are going to protect our investors in investment, we want to be efficient. So far, we think that even if our BITs are not perfect, it's better than nothing. So let's keep them, but let's develop something even better on the EU level. But as I said, it takes time to negotiate. We will have to think about, the evolution of the economy. 10 years ago, or a bit more, nobody talks about BRICS countries. This is something new. So we have to take that into account too, and its investments are two-way streets. And how are we going to find this balance? And this is it's not an easy issue, but we work on that. And but in the meantime, what we want is, even if it's not perfect, let's keep the BITs and find a pragmatic solution.
We've got one question over here, and then we'll go to you and to you.
Yeah, my name is Cecilia Olivet. I work with the Transnational Institute in the Netherlands, but I'm from Uruguay. And I'm just a bit